Imagine that after 20 years of hard work, a single lawsuit from a minor accident or a trivial business dispute takes absolutely everything from you: your house, your savings, and your children's future. Most people believe that having insurance is enough to be protected, but the reality is that the legal system is designed to find cracks in your armor and leave you on the street. If you want to avoid being the next victim of the litigation industry, make sure you stay until the end because we will reveal the secret of phantom ownership, the technique that billionaires use to own everything but not appear as owners of anything in the eyes of the law. Let us begin. Carlos had a net worth of $850,000. He owned 2 investment properties, a family home, and a brokerage account with $200,000. He felt secure because he paid his liability insurance premiums on time. However, one day, a tenant suffered a fall on one of his properties due to a poorly repaired step. The resulting lawsuit was for $2 million, alleging permanent damages. Carlos's insurance only covered up to $500,000. In that instant, Carlos discovered that the rest of his assets, the excess $350,000 and his other properties, were in the line of fire. Carlos's problem is the same as 95% of people: direct ownership. When your name appears on the public record linked to an asset, you become an easy target for contingency lawyers. But to avoid that, here is the strategy you must implement. The first layer of protection is the creation of legal entities to separate your assets from your daily activities. Juan, a friend of Carlos, learned this lesson the hard way after seeing his colleagues' ruin. The golden rule is to never own valuable assets in your personal name. Each investment property should be inside its own limited liability company. If Juan has 3 houses, he has 3 separate companies. If something happens at house number 1, the assets of company number 2 and 3 are protected behind a legal wall. The cost of this first layer is not negligible. Maintaining 3 companies involves paying annual renewal fees of $300 each, filing additional tax returns, and keeping separate accounting. Many investors avoid this because they see it as an administrative hassle, but the alternative is much more expensive. Just like with oversized houses, the operating cost of an asset protection structure is an investment in peace of mind. If the lawsuit against Carlos had occurred within a limited liability company structure, the plaintiff would only have been able to go after the assets of that specific company, leaving his family home and savings safe. The second layer is about hiding the money trail. It is not enough to have companies if anyone with an internet connection can search the public record and see that you are the manager and owner of all of them. This is where the holding company comes in. Instead of you being the owner of the companies that hold the properties, you create a parent company in a jurisdiction that offers high levels of privacy. This parent company then owns the shares of the operating companies in the first layer. This structure creates a legal maze. When a lawyer looks for assets to sue, the first thing they do is an asset search linked to your name. If they find nothing, they will likely not take the case on a contingency or commission basis because they do not see a clear source of payment. The 3-layer strategy seeks to make suing you so difficult and expensive that the plaintiff would rather settle for the amount covered by insurance. It is a psychological war of attrition where anonymity is your best weapon. Owning a holding structure can cost between $1,500 and $3,000 annually in legal maintenance. But that is the price of being invisible to financial predators. The third and most powerful layer is the asset protection trust. While limited liability companies protect your other assets from problems occurring within a property, the trust protects your assets from your own personal problems, such as a divorce, personal debt, or a professional negligence lawsuit. This is the ultimate layer because, legally speaking, you are no longer the owner of the assets. The trust is. However, you maintain control over how those assets are distributed and used. There are domestic and international trusts. International trusts, located in places with very strict debtor-friendly laws, are practically impenetrable by local courts. If a judge orders you to turn over your assets, the trust can legally refuse because it is outside the judge's jurisdiction. This layer is the most complex and expensive to implement, with legal fees that can exceed $10,000 upfront and annual maintenance costs of $2,000. But for someone with a net worth of $1 million or more, it is the only way to ensure that their wealth is inherited by their children and not by some third party's lawyer. Let us do the numerical comparison. Someone like Carlos, with $850,000 in assets, could spend about $5,000 per year maintaining a complete three-layer structure. That represents less than 1% of his annual net worth. It is an operating cost, similar to home maintenance expenses. If Carlos had invested that $5,000 annually for 10 years, he would have spent $50,000. That seems like a lot of money until you compare it to the $350,000 he lost in a single lawsuit for not having protection. Most people prefer to spend that money on a fancier car or a house with more square footage because those are assets they can show off. Asset protection is invisible. It does not generate immediate status, but it does generate generational wealth. The psychological mistake is believing that legal tragedies only happen to other people. The reality is that risk increases proportionally to your success. The more you have, the more incentive others have to find a legal fault in you. The three-layer structure is not just a technical tool, it is a mindset shift from being a consumer to being a wealth manager. A fatal mistake many make is creating these structures after a problem arises. The law has mechanisms against fraudulent transfers. If you transfer your house to a trust the day after receiving a lawsuit notice, a judge will void the transfer, and you could face criminal charges. Asset protection must be built when the sky is clear. Another mistake is mixing personal funds with company funds. If you pay for groceries with the credit card of the company that owns your investment property, lawyers can pierce the corporate veil and argue that the company is just your alter ego, invalidating all protection. If you decide to ignore this strategy, you are gambling your future on luck and the kindness of strangers. In an increasingly litigious world, that is a bet you will eventually lose. The three-layer structure is your ultimate insurance policy against the injustice of the system and unforeseen mistakes. Do not wait for the step to break or the contract to fail to think about your security. True wealth is measured by the strength of your armor, not just by the shine of your sword. If this video has helped you understand how to protect your future, make sure to subscribe, give it a like, and comment on which part of your assets you are most concerned about protecting today. See you in the next video.